Mr. Tang.
My Lord, we were just looking at the information on the form, the online portal, and perhaps we could just have a look at a hard copy of it, that's printed out by the appellants. It's in the bundle at page, I think it's 100 in the electronic copy, 99 in hard copy.
Which bundle?
Core. The core bundle. And the point's been raised by my learned friend in her skeleton that there's an asterisk which says denotes mandatory field, and then she points out perfectly fairly that every field appears to be mandatory since every field is starred. And again, I repeat what I said at the beginning, that the whole purpose of this form is to make the claim for compensation as simple for the passenger as possible. So the booking reference, flight number, date of flight, and a drop-down menu for the reason of claim is all provided. Then one selects the departure airport and the arrival airport, and then some contact details. And then if we skim on in the form to payment details, the claimant with a small c is invited to fill in details for a payment to be made directly to a bank account. Passengers are identified, and what we can see at paragraph 4 is the ability to make a claim on behalf of more than one passenger under the same booking reference number by pressing on the plus sign which says add another passenger. But what I really wanted to draw your Lordship's attention to is the rubric at 5, which is confirmation. And it says, after confirming, the next screen will give you an overview of all data entered in this form. Please check this carefully, as this will help us to process your claim quicker. And then there's a capture form to avoid online submissions by bots, and then various sort of privacy notices. And so when my learned friend said the data simply goes into a vacuum and we have no opportunity of seeing it ever again, that's not right. On clicking the...
Well, I think the point is that once you have submitted it, you can't then get back into that screen that shows you what it was. This is a pre-submission check, not a post-submission check, as I understand it.
No, it's not, my Lord. The rubric under 5 says that when you click on the form, the data that you have entered will be provided to you. I'm dealing with the evidential point and the criticism made of the airline that once the form has been submitted, it's impossible for the claimant ever to see what they've put in. That's not right. The next stage in this form is that it provides the claimant with a copy of all of the data that's been put in. And again, going back to the realism of these claims, Flightright and these claims management companies fill in hundreds and thousands of these forms on behalf of clients. They must have some record of what they put in. And this form provides them with the opportunity in the very next screen, after they've clicked the button, to record what data they have submitted on behalf of the claimants, or in the event of a direct submission by a claimant, for that person to have a copy of the form as well.
Sorry, I'm still not getting this. This says after confirming. I'm not sure what confirming is, other than I'm not a robot. The next screen will give you an overview of all data entered. Please check it carefully. The whole point about that is to allow you to check it before you send it. The complaint is that you can't see it again once you have sent it. I understand fully this is saying after confirming, I assume that you're not a robot.
Yes.
And that checking that you certify, da-da-da-da-da. You get, as you often do, a printout, this is what you're about to send. You hit click, send. And as I understand it, the complaint is once you've hit send, you can't get it back. There's no way of retrieving it. Therefore, you would have to, the complaint is not, you're not given a chance to check it before you send it. It's just you can't produce evidence of what you send after the event.
Well,
I'm not sure, but I don't think that answers the point, does it?
think it answered the point I understood was being made, which was that it's impossible for a claimant turning up at a small claims hearing to provide evidence of what they've submitted.
Other than by taking a screenshot prior to hitting submit.
And that plainly isn't right, because
Why?
what you can do is print out the form after you press continue and before you press submit. All of the data that you enter is available on the screen and could easily be printed by the person filling in the form.
Is there anything on that screen to suggest that you should do that?
Oh, I thought I'd just read the rubric out, which says that's exactly what you should do.
Or print it?
After confirming the... well,
It
doesn't say, and it doesn't say.
It doesn't warn you that you won't be able to get it afterwards. This is your only chance, your one and only chance to save, print out, take a screenshot or otherwise of what you're about to send us. You won't have another chance. This is it, mate.
No, it doesn't. It doesn't say, don't forget to carry on breathing in and out either.
Well,
you know, there is a limit to... I mean, we're also familiar with the concept of information overload. I mean,
yes, but if the email that I think my Lord Justice Birss's point before lunch was, if the email came back said we haven't been able to locate you on our system with the information you provided, here it is, please check it and re-enter. In a sense, then the person would be able to see the error they had made. By definition, somebody who gets the error message back has made a mistake, notwithstanding the ability to check.
yes,
And people do make mistakes.
of course they do.
So,
but the automated email that came back did not ask for every single piece of information in this form again. It asked for a limited amount of information, less than all of the form. And so the reasonable inference from there is that there is an error with one of those details. Where you can see the form at page 14, see the automated email at 148.
do you mean... I'm slightly surprised it hasn't asked again then for the bank details, because how does it connect the previously submitted bank details? How are you supposed to? In fact, you have to go through it again and provide everything again. That's not intended. Surely that's not that list of pica dots with things by it is not a variable list. That must be fixed.
I mean, we're having to guess that. I don't know the answer to that question.
But it's not tailored to the error, because if you took that literally, you wouldn't have to provide your bank details again. And that
I think
can't be right.
the point is actually it takes you back to the form on that hyperlink. So probably you do have to enter all the information again. But so maybe that isn't a good point. The point I was trying to make was that was an answer to the criticism, which was, wasn't it unreasonable of the circuit judge to say take a screenshot? And the answer is no, that wasn't actually unreasonable. It could have been very easily done if somebody printed out the form and checked the details, particularly bearing in mind the form wasn't filled in by the passenger. It was filled in by a claims management company who must have needed to retain a record of what they'd done, because otherwise how did they know that that it was ready to be sent off to solicitors and ready for issue? So railing against the airline for failing to provide data when it was perfectly within the competence and ability of the submitter to retain that information is unfair.
Do we construe the meaning of claim in clause 19 by reference to the consumer, the passenger who's filling it in, or by reference to a claims company who's filling it in? Because your point about the claims company needing to keep records may be a good point and may bear on the meaning of claim, but if it's applied to a consumer, that's not necessarily as good a point.
I dealt very briefly with the issue of claim because it didn't seem to me it was really pleaded well, if at all, in my skeleton. And what I suggested was that for a claim to be valid, and this goes back to your Lordship, Lord Justice Mayall's question at the beginning, or the points raised on appeal, as it were, about what constitutes a claim, is information sufficiently accurate to enable the airline to identify the passenger, flight, and booking reference number.
mean, looking at the automated response, it does begin by saying, thank you for your EC261 claim, not
Yes.
thank you for submitting something which actually isn't a claim.
Thank you for pressing the button on the online portal. We have been completely unable to find your details.
I mean, they seem to have thought that a claim had been made by the person who'd sent this email. But that's wrong, is it?
Well, I'm really loath to try and parse the meaning of. I mean, we've talked about forms in different ways. We've talked about claims in different ways. It's a submission of data, but nobody in the real world talks about, did you submit your data? They say, did you fill in the online form? And the online form is for the claim. The whole premise of this is not that there's been some malicious attempt by people to make up a claim for compensation. It's that the airline is genuinely trying to deal fairly with an application for compensation for a flight delay. And so it's plainly anticipated in this entirely automated system that a passenger has made a claim. The response is, we just can't find you. Can you give us this information again? And a reasonable response to that is, oh, all right, sure. Let me fill in the information. Not silence and then proceedings. In what ought to be manifestly to the disadvantage of the passenger, who then has to pay their damages to a claims management company. It's not. This isn't some trick. It's there, produced by the airlines to try and make this simple, as accepted by the CAA and also by the EU Commission, as we've seen in the Bot judgment. What is unfortunate?
How do you say that the system is completely automated? Well, I obviously understand that the automated system is completely automated and doesn't. If what you mean is it doesn't have any human intervention, is that what you mean?
It is what I mean. Yeah.
Because the airlines do receive claims for compensation other than through the automated system, don't they?
They do, and what happens is that a template rather than automated reply is sent to a passenger in those circumstances saying, here's how you make a claim, use the online system, and referring back to the terms and conditions. So where it has circumvented this form, so if somebody didn't find the form or whatever and writes in on a back of an envelope to EasyJet or even on a formal letter.
No, I was thinking about children.
In that case, I've misunderstood the question.
Clause 19.6 doesn't require children, for example, to use the online form.
No, the later parts of 19.6 say that if you need help filling it in, or you're under a disability, or incidentally, I have not been able to procure a copy of the actual terms and conditions, but I have been told that the only difference is the difference in clause 19.6.1, which says may as opposed to must.
Right, but I thought that there is people who do not have capacity to submit claims themselves are just simply not required to follow 19.6 and 19.1 and 19.2. That's what 19.6.3 says.
Yes, that's right.
So those persons, by definition, must make their claims entirely outside the portal.
Well, that isn't what usually happens. What usually happens is that minors or people under 19.6.3 have been on a flight with somebody else who made the booking, and the person who made the booking makes the claim for themselves and the party travelling with them. But it is possible, yes. And indeed 19.6.4 says a passenger may submit a claim to us on behalf of other passengers on the same booking.
Yeah, but that's a different point. That's your family travelling,
It is, yeah.
which may cover juniors, perhaps.
What I was about to say was that it is unfortunate, and I accept that come the 26th of April, when the airline had found these people and had found the flight and had determined that there wasn't a regulatory defence and had found the booking reference numbers, that they didn't say then, you know what, you didn't fill in the form as you should have done, we couldn't find it on the online system, we now know who you are, here's your money. And that would be an end to it. I do accept that. And that sort of digging in of both sides' positions has led to this ridiculous situation where we've spent a day in the Court of Appeal arguing about this, where the airline says, look, we've got an automated system, use it, and where the claims handler is saying, we're not giving you that information again, done it once, and it's crazy.
I mean, in fact, the terms and conditions we now ascertained apply don't actually mandate use of the automated system, do they?
I think I have to accept that. I mean, it's open to argument because of it says you must use the form, and then it says later on in that.
Well, no. What it says is you must submit a claim directly to us.
Yes. Yes, it does, and then it says you may use the online form. But again, are we going back to this definition of the word claim? It's material which allows the airline to pull all the pieces together and say this is a good one or not. But
if that's right, why doesn't the combination of what was entered directly into the system, coupled with the clarificatory information that was subsequently provided, satisfy 19.6?
No clarificatory information was ever provided. That information was found from the airline's own researches. Every single communication on behalf of the claimants has got the information wrong. Never.
But that's in the PDF attached to the 24th of April email. We don't know if that's true, do we?
How did the airline find them? Quotes from their own research?
By delving into by looking at all of the information available to them, by looking at the names, looking at the flight details, looking at the passenger manifest, and trying to match them up that way.
My lords, if I may, I have taken instructions on what the attachment was to the email of the 24th of April. It was the boarding passes of the two passengers.
So that has provided that information.
So go back to my question. Is the claim, the combination, is 19.6 satisfied by a combination of the use of the portal, which satisfies the first bit, you must do something direct, coupled with the information subsequently provided to overcome the input error, whatever it was, in circumstances where 19.6 doesn't actually mandate use of the portal at all?
When it didn't. Yes, I think so. That's why I said come the, whatever it was, 26th of April.
But in which case the decision of the judges below was wrong, wasn't it?
No, I don't think it was wrong at all. What the judge...
Sorry, I thought you just accepted that what was done satisfied 19.6.
The judge didn't have that evidence, my lord. The poor district judge is dealing with tens of these cases at a time. The claimants put their best case forward, the defendants put their case forward, and the judge made a decision on it.
Okay.
And he was entitled.
So what you say, the decision was right on the basis of the information in front of him, although we can now see, on the basis of the evidence we've been able to piece together, that 19.6 was in fact satisfied, but it wouldn't have appeared that way to the judges below.
Absolutely. And that is an important point. The piecing together of information is not a reasonable way to make these claims. The district judge in that court in Luton deals with tens, if not hundreds of these cases, tens in a day, and has to make up his mind or her mind, whoever it is on the particular day, about whether the claimant has satisfied the burden and whether they've fulfilled the contractual requirements. That judge made no error whatsoever, and the only appeal from that judge's error was on an issue of fact, and the material was not before the circuit judge to gainsay what had been put before the district judge. None of the judges below made any error on the material that was given to them. What we find for the first time on appeal is a snippet of information which allows this court to try and piece together what the district judge could never have done on a second appeal. But what I'm very keen to ensure is that the reality of these claims in the county courts and on the small claims track, and the reality of the way airlines have been allowed, permitted under the regulations, and not necessarily approved, but looking for the right word, affirmed by the Court of Appeal in the Bott case, to proceed by use of an online tool, is a perfectly reasonable way to deal with these claims. And as I say, as it happens, in this case, the claims have been paid. It's not about that at all. It's about This case is all to do with a business of claims management companies making money out of something which could perfectly well be done by the individual passengers for free. My Lords, I wasn't proposing to address your Lordships on either disclosure. Parts of Phipson talk about cards on the table. That's not the regime in the small claims case. The CPR expressly derogates from that. I think the adverse inference point, unless your Lordships are troubled by it, I wasn't proposing to deal with. I can't see any basis upon which adverse inferences could arise where there's no disclosure obligation, where we haven't been asked for the information, and the case has proceeded on the small claims track in the way that those cases tend to proceed.
Yes, well, I think Ms Cochrane either accepted or came close to accepting that an adverse inference that the form was filled in correctly would be a bit of a steep one for her.
Yes. So I do obviously understand that judges try and do the right thing, even in this court, and that we've started from scratch really, trying the small claims case that could have been presented some time ago, but that isn't actually the role of this appeal court. We're looking at whether the circuit judge made an error, and she did not. And Mr. Lord Justice Nugee was, I have respectfully suggested, perhaps misled by the use of the language in the grounds of appeal. There isn't really the sort of issue of public importance that perhaps that is required to arise in order to have a second appeal. Well, unless there's anything else which is troubling your Lordships and which I can help, those are my submissions.
Yes. No? Well, thank you very much indeed. Anything in reply, Ms Cochrane?
Yes, just one moment, if I may.
Yes?
Yes. Just some. My Lords, just some quick points, if I may. Just in relation to the timeline of what was pleaded. In the defence in the witness statement of Victoria White, it's very much that there was no submission made to the respondent. And then when we got to the trial and then the first appeal, it was very much the argument was that there was insufficient or incorrect data in the form. Sorry, I'm just trying to read my own notes. And as I've said, I have made my points about relying on the form and being positively bound. And then what we've got now is the argument that the booking reference was incorrect. And we've, in the course of this hearing, essentially seen that the booking reference and the names, while input correctly, were transposed to the wrong individuals. So, and I have taken instructions over the break, and in terms of requesting the form, that was done, and the most recent time it was requested by my client was on the 19th of August 2022. Just coming to the point that my learned friend made about
But not done before the small claims. You're not going back on what you said earlier.
No, that's the only date that I have.
Yes.
I just wanted to point that to your Lordships.
Yep.
In my learned friend's submissions, he made the point that the system itself, if I may, just to make sure I quote this correctly. he said, and I quote, "The form was designed to be as simple as possible." I would say that it's actually, I would submit that it's not. I think as one of your lordships suggested, sort of just the booking reference number, the passenger name, and the banking information. It's, as you've seen from what's at page 99 onwards, it's 4 sections of data, 4 sections with the first bit, I think you have to input 6 data fields. In section 2, about 7 data fields. Section 3, 4 data fields. And then section 4, another 2 data fields. And all of these fields were mandatory fields as denoted by the asterisk. And so, as I've set out in my skeleton, it's very much that the information input into the form had to be in the correct format, and that data input was limited by certain processing constraints. And if it hadn't, else it wouldn't have passed the built-in validation check on the form.
But how could it be any simpler? I mean, you need to know the booking reference, you need to know the flight number and the date of the flight, because otherwise you can't even start to have the compensation claim. You need to know the reason for the claim, i.e. is it delay or cancellation? And if so, if it's delay, how much delay? You need to know where the flight is going to and from. You might say, well, you could get that from the flight number, but it's not unrealistic to require somebody to say where they were flying to and from. And the rest is just the claimant's personal details, an email, and where their money is going to be sent. I mean, if you miss any of that stuff off, how does the claim get processed and how does the person get paid reliably? I mean, which bit of that are you saying could have been simplified? How could it have been made any simpler?
I think actually I might not use that submission actually, and that was just, I think what I may, instead of that actually, what I may say is if I could ask your lordships to turn to page 100 and I think it's 101, 102. I think my learned friend said there was a point there about being able to
He made a point about section 5, the confirmation
Yes.
section.
where he said, if I may, that the data will, I think, and I quote, "The data will be provided to you. It provides the claimants with a copy of the form." Section 5 does not say that. There's nothing there that says you'll be provided with a copy of the data that you've input. And actually, the first box says that by checking this box, you certify that the information provided is accurate. And that's just a small point, but just to say that that's there.
I suppose you could make the point that it says under confirmation that it will help us to process your claim quicker. Mm-hmm. It doesn't say, if you get anything wrong, forget it, buddy.
It does not say that. It doesn't say that. And then just coming onto the automatic email, if I could take your lordships. If I could take your lordships, please, to in the authorities bundle. It's page 5, paragraph 22 of the case of Boddenko, if I may. Simply because so much else, a significant amount of reference has been made to this case. So in paragraph 22, if your lordships have that.
Yes.
It says, and so Ryanair's evidence was that it introduced a policy under which passengers entitled to compensation under the regulation would receive the whole of that compensation within 28 days of submission. In practice, claims submitted via the online form are dealt more quickly. So once a claim has been submitted, there is an immediate acknowledgement by way of email if the passenger has provided an email address. It says the claim is assessed by Ryanair, and Ryanair provides its substantive response to the claim to the same email address within 24 to 48 hours of submission. So just, I know that we've been talking about this case a lot, but just simply to say that Ryanair, in the Boddenko case, did have a process by which the actual claim would be substantively assessed, whereas EasyJet, there's no evidence that EasyJet have ever done that, apart from in the I suppose in effect in relation to the email of the 26th of April 2021. And then the fact is that in that, the letter rather, of the 26th of April 2021, and the fact is that in that letter, as I think as your lordship said, the respondent had all the information they needed to be able to tie the names of the passengers to the booking information. And I would submit that simply saying that because not every detail had necessarily been entered correctly into the form does not mean that there's no claim, and to say that there is no claim would amount to a material obstacle under, I think, Article 15 of the regulation. I think your lordships have discussed with my learned friend about the terms and conditions that were applicable at the time, and the fact that the word of use may is involved. I know that there was reliance placed on clause 19.6.2 at one point in my learned friend's submissions, but I would submit that that was included in the defence, and we don't actually know what the copy that was in force at the time, what that actually said. As with this letter as well of the 26th of April 2021, it was essentially a rejection letter, and under paragraph 71 of the case of, in the judgment of Lord Justice Lewison, he says that once a claim has been rejected, you're entitled to, essentially, I may quote.
Well, once it's rejected, you can bring the claim in court if you want to.
Yes, it's just going for the exact quote.
Point? Right, that's the sense of it.
And so at that point, the claim had in effect been rejected. My clients waited more than 28 days from the 26th of April. They waited until the 8th of June to issue their claim. So I would submit they have complied with clause 19.6.1. And just, I know that my learned friend also, this is another point, said that after the first appeal they offered to pay the compensation. And I wasn't planning on dealing with this here, but in relation to costs. There was an offer made, but there was just to pay the compensation, but there was nothing done in relation to costs. And so, if I may just take instructions quickly.
Yes,
So
sorry.
I've just taken instructions. So it's correct that after the first appeal, the respondent did offer to pay the €500 in compensation, and it was sent to my client's solicitors. There was no mention of the costs that had been incurred previously, and so my clients did ask for some for costs, at which point the respondent essentially asked for the money to be paid back and said that the offer to pay compensation had been made in error. So I just wanted to clarify that, because I know that a reference has been made to that.
That's not right. The offer was made and payment was tendered into the solicitor's account. It was then rejected, and in response to that rejection, a letter was sent saying, well, we didn't mean it anyway, give us the money back.
Yes. All right. Well, it may be we'll have to go into all this when we deal with costs.
And then just my final point is that, as I think we've already gone through, if everything had, and I know we don't have evidence of the form, but it had potentially been entered correctly by one error, if EasyJet's system rejects it based on that, and that alone, I would submit that that amounts to a material obstacle outlawed under Article 15 of the regulation, and simply the fact that EasyJet's system is lacking in some senses, and that you can't have a copy of the form even to show you what you've potentially done wrong, I would submit is a very important point for your lordships to consider, and that concludes my reply.
Well, thank you very much. Thank you, everybody, very much. We're going to reserve judgment. As you will know, we will send you out a draft judgment once we have prepared it. that will be sent to the individuals whose emails have been identified. I think one of our clerks will have been in touch with you to make sure that we have the right email addresses. I'm sure that Council will know, but I'll say for everybody's benefit that the Court takes the provision of draft judgments subject to an embargo very seriously. If you're not already familiar with what is said in Counsel General for Wales, which I expect that you are, you must look at that very carefully and ensure that the draft is only used for the purposes which are permitted by that judgment. We will then invite you to agree a draft order if you can. If you can't, we will have submissions in writing and we will deal with the submissions in all probability without a hearing. I say in all probability because the costs question might be quite complex in this case, because although the usual rule is that costs will follow the event, and there isn't much to say about that, points which may affect issues of costs have been lightly touched on during this hearing, and I can see that whoever loses the appeal may want to say that there are reasons why they shouldn't have to pay the costs or the full costs of the appeal or indeed of the proceedings below in view of the way that which this matter came about. So what I'm going to direct is perhaps unusually that we will have costs submissions in writing sequentially rather than exchanged, and that whoever loses the appeal should go first, because the burden will really be on them to say that the usual rule should not apply if that is something that they want to say. The loser unusually will go first, and then the winner will have the opportunity to say that the usual rule should apply. I hope that's all clear. Anything else?
An appeal about the burden of proof and the
well, quite.
That was perfectly clear. My mind.
It all sounds a bit odd, but I hope you understand the rationale. Thank you both. Thank you all very much.